All right. Thank you so much for joining in for another session, Community Thursday sessions. This one in particular, I think, is very important, especially for women in today's world. I think everyone now has assets, has their own property, and I think it's very important to learn how to be able to decide and plan where this goes. So we've partnered with AasaanWill that will talk about will writing and succession planning. This was a very popular demand from our community as well. So a big thank you to them. From AasaanWill, we have Monika here with us. Monika heads the legal department at AasaanWill. She also is a corporate legal professional with 11 plus years of experience in compliance review across industries in multiple jurisdictions, including corporate law, industry law, labor laws, etc. So thank you so much, Monica. And it's over to you. Please take us over. For folks who would like to have more personalized discussion, while we do have the chat box, we also have 20 minutes of discussion time at the end of the session. And we also will have Shreya come in and talk about how she is partnering with us on Will and how she's managing her will writing. So that will happen towards the end of the session. Over to you, Monica.
Thank you. Thank you so much, Arushi. And hello, everyone. Thank you so much for your time today, for coming This is very, very important. And I'll just share my screen and we'll just start with the session. I hope my screen is visible to all of you.
Yes, it is visible.
Yes. So first of all, being a woman, we grow up learning how to manage emotions, responsibilities, marriages, families, children, and sometimes everything at once. But nobody really teaches us how to prepare our families for life's uncertainties. It becomes visible only during emotionally difficult moments. When a medical emergency happens, a sudden loss in the family, or sometimes a simple financial process that becomes unexpectedly complicated. And then families realize they knew that the person we were close, we were deeply know each other, but we don't know about the paperwork, the assets, the legal process, or whatever the wishes. Even honestly, before I started working into this field, succession planning, I genuinely believe that wills and succession planning is only for the older people or just for the ultra rich families. But over the years, this reality have been changed. And I have seen it's very different. So today we'll discuss about the importance of succession planning, why it's important, what are the succession laws, what is the myths around nominee versus legal heir, and what are the key elements, key components of writing a will. So modern women today are carrying more responsibilities. We are earners, caregivers, founders. We have our startups. We are single parents, decision makers. So our legal system still work on based on documentation, not on assumptions. So why succession planning has become even more important? Because modern families are complex than our traditional inheritance assumptions. Our family structure has changed. It's not like before. The children are living abroad, they are moving out of country, and there are, married daughters who are supporting the parents. It's not only the son who is taking care for the finances in the family. So sometimes the families, the parents are also dependent on their daughters. And we do have minor children. So this is just the overview of to give you the context about it. So now the questions which are unanswered: who should inherit our assets? Who gonna manage the responsibilities? Are the legal heirs will be same as our intended legal heirs to whom we want to pass on our legacy, our hard-earned money? So now I'll start with the core problem. The biggest problem in India is there is no single asset register wherein your family member, your children, your spouse, they can just log in and see where you have invested. And our assets, our money is, scattered. One thing is in the bank account, there is mutual fund, FDs, there is insurance policies, flats, fixed assets, gold, jewelry. There's a lot which we are not documenting. And our family member, they don't even know what exists, how they gonna claim it. So this is the situation. I want to keep it as interactive session. It's not like I'm just doing the presentation and then it becomes a boring session for all of you at some point of time. So let's keep it interactive, and then you can share your experience, your questions as well around it. So this is about unclaimed assets. So I would just like to ask all of you, have you ever seen any situation where someone passed away in your family, in your network, and the surviving family members are just struggling to see what all the assets are there? Have they invested in FD? Is there a mutual fund? Is there any insurance policy in the family? If you can just do yes or no in the chat box, that would be fine. Have you ever seen anyone struggling to find out the assets, what all assets are existing in the family? Okay, it's quite interesting. Yes, yes, someone, okay. Okay, that's nice. So you already know that what the real picture is. So now coming back. So currently in India, 1.5 lakh crores of assets are unclaimed in various financial assets. It could be bank deposits, PPF accounts, insurance policies, FDs, mutual funds. Because the surviving family members have no clue that their parents, their husband, or their any grandparents have invested in these assets. They have no clue. No one is going to claim that. And at some point of time, that fund will be moved to the government's administration department. So we are doing all the hard work during our lifetime. We are saving the money. We want to safeguard the future of our loved ones, but eventually that amount is not reaching out in the right hands. So that's the biggest issue. So first of all, we'll just discuss around the problem statements, and then we will see what solutions are available via succession planning tools, and then we'll discuss each other's queries. So we see that currently 12 million plus court cases are already pending in our Indian courts, across district courts, high courts, supreme courts. A lot of people are dying annually. Accidents, disease, cancers. I mean, a lot of things are happening. And these are untimely, unfortunate situations wherein the family members are not prepared for the unfortunate situations. So now let's check what happens legally after demise of any person. So sometimes the bank accounts, the investments, these may freeze. They will ask some kind of documents. So I'll tell you a story. So we have seen the situations wherein the husband and wife are there. There is no son in the family, no children, and it's just the couple. And husband passed away in any accident or anything. Then the surviving spouse, wife, she wants to claim the assets. She wants to claim the FD or any other amount from the bank. The bank will ask a list of documents. It could be death certificate, KYC documents, and the proof of legal heirs. That just show me the proof that you are the wife, or if the children are surviving, just show me the proof that you are the surviving son of your mother or your parents. So there is a list of documents which can be, just running from pillar to post for your loved ones, and it can be emotionally burden up for them because already they are just facing the traumatic situation. They have lost their loved ones, and then on top of it, they have to do these paperworks. And third issue is succession law automatically applies. So definitely my next questions will be, do you know that what is the legal hierarchy? How a legal hierarchy work? So if any of you can just type in the chat box how the legal hierarchy of a married woman works. She has her self-acquired assets, okay? And then she has a husband, in-laws, like a good joint family. They are living in all together happily. And something happens to the wife, the women. Now you tell me that how the legal hierarchy should work. Her self-acquired assets, how these assets will be distributed among the family members. I'm just looking in the chat box. Husband, children, mother and father. Okay, nice. Husband and children. Someone mentioned children and husband are class A first priority. Okay, children.
We have a question on what about unmarried people?
Yes, we will discuss that as well. Husband, children, husband's family. Very nice. So yeah, I mean, these are very insightful answers. Thank you everyone for participating in it. And yeah, I'm glad that you have, very close idea about it. So yeah, let's go through the PPT. I'll just show you how the legal hierarchy works for men, married, women, married, and unmarried men and women as well. So let's take an example for married situation once. Yeah. So this is how the legal hierarchy works for a man. If a man dies without writing a will, then his entire assets will be equally distributed among mother, child, and wife. Here, father gets nothing. So now these laws were created in 1956. And now we are sitting in 2026. So that's why in the previous slides I mentioned that modern families could be more complex. The laws were created based on the earlier situations, earlier circumstances. So now father gets nothing. So we have seen a lot of scenarios where there are no, good relationship among all the family members due to any of the reasons. And the father is struggling. First of all, they have seen the death of their son during his lifetime. So it's worst for being a father, anyone. And then he is dependent on wife and any other family members for his health, for his financial well-being, etc. And nobody is there to take care for the father. So it's not about just the legal hierarchy. We should document our wishes, our intentions, because law does not understand your needs, your emotions. They don't know who needs more care, who needs more support in your family system. If we document all this, then we can mention our intentions. We can ensure that our loved ones are taken care properly. Now let's discuss in case of women. If a Hindu married woman, so first of all, these laws work based on your religion. If you are following Islam, there will be a separate Muslim laws. And similarly, so based on your religion, the Hindu succession or the Muslim succession, Indian Succession Act will be applicable. So on a broader point of view, we are just discussing about the Hindu situations here. So for a married woman, what happens? The entire self-acquired assets. I'm not talking about ancestral or any, marriage time gifts and all. It's self-acquired assets we are earning with our hard-earned money. So whatever self-acquired assets are there, it will be equally distributed to children and husband. Her own parents get nothing. So I remember I saw some of the messages in the chat box. Someone mentioned that yes, her parents, or someone mentioned it's husband's parent. So this is the real situation. We work based on the assumptions. We think that yes, my parents are closer to me. I am only daughter, single daughter. I don't have brother in family. So if something will happen to me, my FD will be going to my parents or my mother for their well-being. But practically, it won't happen like that. even if your parents are financially or any other way dependent on you, on the daughter, but still the law does not understand this and it will work based on the legal hierarchy, which is created as a rule book. Any questions here? Anyone, if have any thoughts, we can you can unmute and then we can discuss this. How does legal hierarchy looks
For
for
married
married
couple
couple
with,
with no children?
and some people are asking if it's different based on religion.
Yeah, so if there is no children, then everything will go to the spouse. So husband and wife is there, no children, then husband's entire assets will go to wife and mother equally. If mother is not there, husband's mother, then it will be entirely to wife. So in this situation, when there is no children, so for example, I don't have any children, I'll say my husband's entire assets will be coming to me. But if we have mother-in-law at house, then his assets will be equally distributed among the mother-in-law and me. So it's not 100% me. So that's where the family disputes, the bonds, can be disturbed. Yeah, some personal questions around the distribution we can discuss during the Q&A round, like how you want to distribute and take care of your children and all. All right, I'm moving back to the PPT again. Yeah, and this is really important slide. Being a mother, I feel that this will is not only for the properties, it is for safeguarding our children. Now just see if something happens to both parents, who will take care of the minor children, their education, their emotions, their finances, their health, their schooling, like who is going to manage all this stuff for our children? So we can do a legal guardianship with a will document. In a will, we can mention any of our loved ones, our friends, our extended family, our sister, brother, like that, to appoint as a legal guardian. If anything happens to both the parents, then that legal guardian can ensure all the, well-being of your children, their schooling, their expenses, and any other, if they want to send the children to study abroad or anything. So if we can document everything, it will give you a nice peace of mind that yes, our children's future is secure. He will not struggle anywhere, and someone is there to, provide that love, that care. Now let's discuss how unmarried circumstances work. So if a man, he's unmarried, then his entire assets will go to mother. Here also father gets nothing. I mean, being a lawyer, I also don't understand why this discrimination here. Father gets nothing. It's everything will go to mother. And if the woman is unmarried, then the assets will go to the parents equally, father and mother. But here the situation could be sometimes we have siblings, they are dependent on us. We have some, close relationship with any other member in our family. Still, it will be entirely going to parents. But if we write a will, we can ensure if we want to donate something, we want to do charity or any other specific reason close to our heart, any other family member who is close to our heart, it could be your nephew, it could be any of your, cousin. So yeah, if you write a will, you can ensure how your money will be bequeathed. Now I'll just share one quick story here because I always believe stories we can, feel the situation and just understand it in a better way. So we have seen one situation where a mother, a daughter, they were living in India and husband was just moving here and there. And there were other siblings, they moved to Australia. So there were three children, two sons, they were moved to Australia, and mother and daughter, they were living together and they were very close to each other. So now suddenly something happened to mother. Mother passed away. And now the daughter thought that naturally it's my mother's property and we are living together. We loved each other. I was always there for my mom to support her. And, I stayed with her. Everyone has moved abroad, but I was staying here. So naturally, it's my mother's property. It will come to me. But when she visited the revenue department, the housing societies, the authorities asked her to provide legal heir certificates just to prove that you are the daughter, you are the surviving family member. So this is the pain point that we have to prove there is a documentation, legal heir, succession certificate, letter of administration, and many other things. And second problem is the entire assets, even if the mother-daughter were very close, the entire assets won't transfer in the daughter's name. It will be an equal split among husband, other siblings, and this daughter. So I hope you all could relate it. Any question around it?
I see a few questions. One is, what about unmarried women with deceased parents?
Yeah, if parents are not there, then the siblings come into the second legal hierarchy. If no one is there in the first preference, then it will go to the siblings. So clear answer, unmarried women with deceased parents, the entire assets will be equally distributed among the number of siblings.
I believe there's another question where it says, is any overhaul or modification of these laws being considered in India?
So yeah, it's an interesting question. Thank you for it. So modification. So recently there is like interesting modification came in succession laws. Probate. I'm assuming that many of you must, be aware about this term probate. So whenever we write a will and our assets are located in Bombay, Chennai, and Calcutta. So in these presidency towns, if we have any of the assets, even if we have a will in place, our family members need to probate that will. It's another layer of, justifying that this will is a genuine document. So fortunately, in December 2025, this rule has been abolished. It's a long years, regulation which was going unnecessarily from the British era. And fortunately, this is the new and, great reform in the Indian judiciary that this probate system has been abolished. So thankfully, if we write a will, even if our assets are located in these cities, Bombay, Chennai and all, we don't need to get a probate of the will. Our will is the final document and our family members, it's just ease of their life that you have a will, then just go and distribute your assets based on your will.
I also
And
believe that there
yeah,
are quite a few questions here. Do you want to do this at the end? Most of the
yes,
Q&A.
yes, so
Yeah,
that
okay.
we don't break the flow of our, all
Okay,
right.
thanks.
Yeah. So till now we have discussed about the problems, what can go wrong, what are the situations, unclaimed assets, the legal hierarchy. Now let's talk on who needs a will. To be very honest, everyone needs a will the moment we started earning, the moment we have responsibilities on our heads. So here is just, some examples that get married couples, first home buyers, if you have minor children, if you are single parents, if you are LGBTQ community, if you have separated, divorced, or retired elderly people. So everyone falls into that category. There is no age bracket that anyone who is in their 70s or 80s should only write a will. No, it's not like that. Anyone, even if they are in their 30s or 40s, if they have children, any responsibilities, any dependents, or anything they have, it could be one FD or one flat, even though they need to write a will so that they can safeguard their family from the futuristic paperwork and by default legal hierarchy. They can work based on their needs, their support, their emotional requirements in the family. Yeah. So why it is important to write a will? Your wishes, your intentions will be valued. There is no by default legal hierarchy. It will definitely prevent family disputes because we already discussed 12 million plus court cases are already pending due to inheritance disputes. So if there is a will in place, it's a straightforward, and then it will prevent disputes. And it can protect your needs of specific family members. If you have any specific need, children, elderly spouse, or any dependent parents, any unmarried family member, if you have unmarried sister, unmarried brother, divorcee, or anyone, so any of these situations in the family complex structure, it will ensure to take care for them as well. And again, it will save time. Obviously, it will reduce the costing and stress for your legal heirs because they don't need to go with the succession certificate, with the legal hierarchy, and all this stuff. Because if you want to get a legal heir certificate in India, it will cost you like minimum 1 lakh plus expenses. And then it will minimum take like 4 to 6 months of time. So now this coming generation, they might not have that much, energy, time, and patience to just go through with all these legal paperwork in India. So yeah, these are the benefits about the will writing. Now, we will be moving towards nominee versus legal heir. So first of all, I would like to understand from all of you, what are your thoughts? Uh, so for example, you have nominated anyone from your family as nominee for your FD, for example. So what do you think, being a nominee, that family member, that nominee will acquire the entire amount, or do you think there is something, there is a difference between the nominee and who will be the actual owner? Should I repeat my query? So I want your thoughts around nominee versus legal heir. Do you
People are
think
saying nominee.
yeah, nomination is done everywhere in all banks, accounts, remits. So yes, it should go to the nominees. Okay. Bank nominee will get full amount, whoever it is. Okay. In FD and bank account, the nominee gets the amount. Okay, nice. Someone says they are different. Difference is there. Nominee is responsible for distribution. So you see, I mean, we are just 30 people in this room and we have our different opinions, different thoughts. Okay, but law does not have different thoughts or, different things in its rule book. It's a fixed rules that we have to follow, irrespective of our, needs or requirements for the time being. Okay, I'm glad again. Yeah, thank you everyone for just sharing your thoughts around this. I really love interacting and getting the real, things so that I can, take this, that yeah, what is the real pain point? What are the people's thought and all? So it gives me good insights to get your thoughts. Okay, so let's discuss around nominee versus legal heir, how it works. So first of all, nominee means a person who is nominated to act on your behalf. It is treated as a caretaker, as a custodian, as a trustee. Okay. But legal heir, it refers to someone who gonna bequeath your assets, whose name is mentioned in the will, or if there is no will, who will be the final of your assets. So just to give you an example, I'm saying my brother is nominee for my FD. So now, as per the assumption that I have nomination in place, my FD will go to my brother because he is the nominee in my FD in my bank. Now, I got married. Brother is not as part of my legal heir. My husband, my children, my in-laws, all these are part of my legal hierarchy. So if something happens to the women, the FD amount will not go entirely to the brother being nominee. The nominee will be treated as a custodian. The bank might hand over this to a brother, but it's the responsibility of the brother to hand over that FD amount to all the surviving legal heirs, the husband, the children. So my main point here is nominee is your custodian, not the actual consumer, not the actual owner. So even if somewhere your wife is or your husband is or your son is the nominee, he or she will be responsible to equally distributing all the entire amount among all the surviving legal heirs. So if I say that 5 CR will be nominated, my wife is my nominee and this 5 CR will be given entirely to my husband. But my husband will have to equally distribute. If he will not do so, the legal heirs have the rights to challenge that nomination. They can file a court case and they can claim their shares. So my main point here is even if you have a nomination in place, just write down a will, clarify that your intention is same. You want this entire amount to give to your nominee or you want it to be equally distributed among these XYZ members. So this is how it works. And will document always supersedes. And if there is no will, then by default, succession laws will prevail over the nomination. But here, insurance policy is one of the exception of this nomination clause. In life insurance, whosoever is your nominee, they will be getting your amounts. Okay, so now let's move towards what are the different types of wills in India. It's a last will and testament, most common in India. Joint will, it is most common when the couples, husband and wife, have joint assets. So for example, you and your husband have a jointly acquired assets, a flat or anything, then you can write a joint will. It also has its pros and cons. So based on your family structure, your asset size, nature of assets, we recommend you should go with the individual will or the joint will. But joint will is, bit typical. And ideally, it's always good to write two separate wills. So again, based on your structure, your particular situations, we recommend you should go for joint or the separate will. Then mirror will, it's couples, they are just giving their assets to each other. Husband says, my entire assets will go to my wife and vice versa. Okay. Now, this is very important and hot topic in India, living will, advanced medical directives. So you must have seen some recent news and cases about the living will. It's about our medical treatments, like during any sudden illness or any serious medical circumstances. If we have a document known as living will in place, it would be a lot more easier for our loved ones to take the decisions around ventilator or food or anything. So doctors prefer that is there any living will so that the decisions can be done on these parts. Now, notarized will and registered will. So in India, the digital will or e-will that are not recognized, it needs to be wet ink signature. And then notarization and registration are optional. So we'll discuss it in detail. What is a notarized will versus registered will, which is more a strong document. Before that, I just want to highlight key elements to consider while drafting a will. So first of all, identification of testator. The person who is writing a will is known as testator. We have to appoint someone as an executor because this will document comes into execution after demise. So there should be someone who is knowing that yes, X person has written a will and I am the executor. I'll inform the family that there is a will and this is how he or she wanted to distribute the assets. So executor is really, crucial people of your will. And then accurate asset listing, your FDs, your mutual funds, your digital assets, your IPRs, your flats, lands, or any type of assets. In India, you have to list down. So if you have any assets in foreign countries, then there will be a separate document. So it's a country specific document. Then specific bequest, how you want to distribute your assets. If you want to do charity or donate something, then that's also possible via a will. Then there is a residuary clause. It's a bit technical. So it covers your futuristic. So for example, Arushi might say, Monica, I'm writing my this will today, but what if after 2 years or 6 months, I'll purchase a flat or anything? So how it will be taken care? Do I need to, update and rewrite my will every year or what? So in these type of situations, this residuary clause is very important. It takes care for your futuristic assets. You can name someone that if I might acquire anything, this will also be given to my husband, my mother, or anyone. Then guardianship for minor. So either we can create a separate guardianship document, guardianship deed we call it, for appointing legal guardians for our minor children, or we can do it via a will also. Then proper witnessing. So two-person needs to be the witness of your will. It's mandatory. If you are writing a will, signing it, but there is no witness, your will is no legal validity. It will be invalid will document. Medical fitness certificate is also important when you are you have age issues or any medical issues, you are undergoing any treatment. So it's a supportive document. It's optional, but it's recommended. Excuse me for a minute. Now, how AasaanWill can help you create a valid will. So first of all, we understand your family structure and then recommend the correct type of will. It should be joint will, you should write a living will, or you should go for a notarized or registered like that. Then you just need to create a list of your assets so that nothing goes in the unclaimed assets. Everything is listed down, and then like you not need to mention every single information. It's just the high level information about your assets. Then you get your will draft from comfort of your home, and then notarization or registration end to end. So notarization and registration, it's an offline process wherein you need to sign in person your witness, and we take care for the appointments at the government department, the documentation, coordination, and everything. Okay. So now I'll just move towards notarization versus registration. So notarization, both are not mandatory, but it's recommended. So notaries will be done at the notary public and registration will be done at the sub-registrar office. And for the basic wills, like there is low risk of dispute, it's just one son or one property, then you can go for a notarized will. But if you have high value assets, multiple legal heirs, or you see that there could be some challenges or some issues, you should always opt for the registered will. So it will be recorded in the government record and you can acquire copy or anytime. Like it's a proper biometrics and every signature will be there at the sub-registrar office. Now, since in this will document, this is, again, it's very sensitive and once in a lifetime sort of document. So yeah, the data will be 100% confidential and secure. During this will writing journey, only the lawyer will be able to see whatever information you have shared for the purpose of drafting, and every, encryptions and security of your personal data will be taken care end to end. Now we have received a few queries around gift deed versus will. So gift deed is also one of the important tool of succession planning. So a lot of people ask me this question that Monica, can't we do the gift deed, that I'm doing this gift deed to my daughter, but it will come into force after demise. So first of all, let me clarify. Will is a document that comes into effect after demise, but gift deed is a lifetime document and lifetime transfer. You cannot say that I'm doing this gift deed to my daughter for this my flat in Bombay and it will be given to her after demise. No. Gift deed, the moment we sign that gift deed and register it, it's an immediate transfer from mother to daughter. So that's why we need to, think about the situations, the requirements, the purpose. Then we can see which tool is more suitable. We should do a will or we should do a gift deed. And about other services, so yeah, we start with, personal meeting or online video conference calls and all to understand about your family structure, your needs, your complexities. And then we recommend you should go with the will or there is a family private trust as well. It's altogether a different topic. So I thought, we'll keep it separate, will and trust. But yeah, we can help you with creating a private trust, charitable trust. And if you have a good business, then how the business succession planning will work. So structuring around that. And beyond that, like succession certificate, gift deed, release deed, power of attorney. So power of attorney is a document wherein you want to assign someone to act on your behalf. For example, two sisters are there. One is living abroad and she has some assets in India, but she cannot come, back and forth just to sign some paperwork, do the paperwork. So she can give power of attorney to her sister residing in here, and then she can act on behalf of the another sister. So these are about all, different tools of succession planning. Yeah. Now I would just let's open for the Q&A. And before that, I would like Shreya to share her experience around, this succession planning, will writing journey, and then we'll move towards the Q&A session.
Okay, so very quickly, folks, I just want to say that a lot of times women don't have even the awareness of their legal rights and what is, something that they can do for them to get access to their wealth, to also list down what you think as wealth is. Right. So one of the most important steps is to actually go through the form. So when I signed up with AasaanWill, it was very recent. I think we had a visit of if you can stop sharing the screen.
Sure.
Yeah. Yeah. So if you're looking at really sitting down with what are your assets, what access do you have to these assets? What can they be? I think the first thing is to fill out the form in detail because then you realize what can be looked at as assets. For me, it was interesting because I'm also wanting to look at a lot of the things that I have that are non-tangible assets. Like I want to decide who the circle of people are who will get my best saris, for instance. It's a simple thing, but I would like to leave behind special saris that are important to me, to people that I would love for them to wear, right? So it's simple things like that that you haven't even thought of. And for me, I think going through the process involved also understanding what my assets are, what my rights are, who do I leave what to, all of these dynamics. So I think it's very lovely as a process because you sit with what you own, you sit with what you have as things that you can bequeath. And from there on, it's a process of really understanding what it is that you need to do. And it's a step-by-step process. And AasaanWill made it really easy. Of course, there's a lawyer visit, but the simplicity of the process was what was incredible for me. So go ahead, feel free to ask Monica your questions. It's also interesting to sort of remember that we still live in a world where a lot of women don't even have access to their earnings. A lot of their monies are managed by the men in the family, right? So it's also important for you to start thinking of what does your money mean, right? How do you look at your money? I love books like Psychology of Money, etc., which you can really read. And of course, there's so many resources. Grace Hopper, we've had a couple of sessions on financial planning, etc., of when you're here. But when you transition and when you leave, what is it that you can do? Yeah. These are things that I would love for all of you to go ahead and ask Monica, and we'll take it from there.
Thank you. Thank you so much for your lovely words. Yeah, so quickly we'll start with the questions. We have a few in the chat box. So I'll take this one. If a woman has parents' side, then those assets goes to parents and not husband. So correct. So here in the PPT slides, we discussed about the self-acquired assets. But if these are ancestor, then it will go back to the same legal hierarchy they have acquired. This depends on religion. Yes, the Indian Succession Act, these laws depend on based on your religion. Yes, for Christians, there is a different legal hierarchy. How does legal hierarchy looks like for married couple with no children? We have discussed. It will be to the parents. What about parents added as nominees to our bank account? So even if it will work the same way, the nominee versus legal heir, parents added you as nominee, but it will be equally distributed among all the surviving legal heirs as per by default legal hierarchy. I'm divorced and custody of my child is with her father. I want my child to benefit. How can I navigate? So yeah, in these situations, a will allows you, it gives you a flexibility to write the intentions. And even if the child is not with you or the custody is not with you, you can mention in your will document whatever assets you want to give for his or her education, for any of the needs, you can mention it specifically. So that's the beauty of this will document. It allows you to, respect and honor your wishes. What about single mother? So yeah, again, for single mother, if separated, then the laws will work differently. If divorce decree is there, it works differently. So based on who all are the surviving legal heirs, it will work by default. But yeah, if you write a will, you can mention the way you want to distribute. It could be your siblings, your parents, your friends, or anyone, even the blood relatives or the non-blood relatives. What about unmarried women with deceased parents? We have discussed this legal hierarchy. Do we need to specify bank FD, mutual funds, and all other fixed and liquid assets, gold, etc.? All should be mentioned in a single. Yes, there won't be multiple wills. For your assets located in India, there will be single will. For your FDs, mutual funds, even you have assets spread across multiple states. If you have something in Bombay, Hyderabad, Bangalore, everything will be captured in one single document. With will in place, the legal hierarchy can be overridden as per will owner's wish. Yes, absolutely. That's the objective of this, entire document. You can override the by default legal hierarchy and the laws. The laws give you the flexibility. If you write a will, you can do this with your wishes, your choices. Okay. Even office, we have given nominees, PF, etc. So this PF part is, very important. If you will, I'll ask you how your PF will be distributed to your loved ones. We will be just clueless. Even I don't know. I don't remember that, my UPIN number or anything. So these things can be tricky to be transferred to our next generation. So if when we are listing down our assets, we need to create a separate what my family should know checklist. So we have a format wherein I give you, I help you that what my family should know. So in this document, we capture all our digital passwords, our, confidential information. It's an internal family document because without these particular information, our loved ones won't be able to access. If I'll tell you your sister, your mother, they can go and access your PF. Can they claim your PF amount? No. They will need a lot of paperwork. They would need some, documents, OTPs will come. So we have to structure the entire list that which is that mobile number, which is connected with our Aadhaar card or with the OTPs and all. So these are the very, next layer of these discussions. So once we create a will, we should also have a confidential internal checklist in our family so that everything is structured.
You can scroll down to who ensures the
Yeah,
nominee follows the law.
sure.
The
Okay, this
question
is
is,
about the
yeah,
thoughts around nominee.
yeah,
Is living will part of registered notarized will or separate? Living will is a separate document. It has no connection with your assets. So last will and testament, these types is to safeguard the assets, how you want to bequeath, distribute your assets after your lifetime. And living will is the advanced medical directives, like during the serious illness, how you want your family members to take the medical decisions on your behalf. When you will be incapable, who will take that responsibility? So these two are really separate documents. Can we have more than one will, one living will and other? Yes. So we can have two wills, one for our property distribution, another for our living will, medical directives. But for assets, there won't be, multiple wills. Single document capturing all types of your assets. Can the witness be the legal heir itself? It's very nice question. Yeah, so witness should not be your direct beneficiaries or your legal heirs. For example, your wife, your husband, your children, your parents. These should not be the witness. It should be any person who holds no interest or rights in your property. They are not getting anything. So they should not be biased. So any of your friends, your extended relatives, your colleagues, they can be the witness. Can any doctor authorize the medical condition or only government? So it's not government doctor, it's MBBS or that level of doctor, and that they need to sign it on their letterhead. So there is a format of the medical fitness. It's just the soundness of mind. It's not that you are undergoing any treatment per se. It's just few lines that the person is able to do a contract, an agreement. He's mentally sound. No one is forcing him to write this document. Next question is, can CA, lawyer, legal firm be executor instead of a person? Yes, it's possible. I have joined late. Will the recording be? Yes, Arushi will take
yes,
care.
yes, it will be. I will do that. There was a question in between where it says that who decides if the nominee, so the question was, what if the nominee doesn't distribute money to the legal heirs?
Okay. Then legal heirs have the right to, challenge that nomination. They can file something, petition in the court and prove that we are the surviving legal heirs. Then the court will take that decision. So it will be again a long dispute in the court. So legal heirs always have the right to challenge that, and they can ask the nominee to give their share.
Yes. And then there was a question now here where this says, how do we ensure that the will created by a lawyer with full proof so that the successor does not face any issue? I think you said that there is multiple ways.
Yes, so we discussed the key, components, elements of writing a will. So first of all, wet ink signature is mandatory. You cannot just, put your DSC and say that yes, it's genuine document. And two witness is mandatory. At this point of time, it becomes a legally valid document. There is no fixed template key. It should have this language. It should have these wordings. It's purely, customized based on your family, your assets, your requirements. But mandatory part is signing plus two witness. And then registration and all is a, extra added layer of security.
Right. And then the next question is, who are the legal heirs of a married Hindu woman?
For married Hindu women, we discussed during the slide also, the legal heirs are husband and children. If husband is not there, someone is widow, then mother-in-law becomes the legal heir. Her own parents, mother, father, they won't get anything. They are not covered in the preferred class one legal hierarchy.
Right. And then people asking if they can update their will later on, like once they
Yes,
created when
yes.
they're unmarried and then once when they're
Yeah,
married.
so that's again, it's a beauty of this document. There is no restriction. You can update it n number of times, But yeah, when we are writing this document, we take care for, futuristic situations, the residuary clause and all, so that even if we miss to update it, there should be no harm. It's great to update it, but even if due to any unfortunate situation, someone missed to update it, they should not suffer because of it. So we take care for everything during the drafting.
Okay. I think we can take only 2, 3 more questions in the interest of time.
Yes.
But like a few questions you already answered, where it says for married couples, what is succession law? For demise of any partner, we just covered that, I believe. And then it says
What
that
is
for an
the
unmarried woman,
yes, yes, please.
sorry, it says if she says, I am unmarried, can my will be in favor of my niece?
Yes, yes. So with a will, you can give it to anyone. There is no restriction. It could be any of your blood relative, non-blood relative. It could be a charity. So there is no restriction that you cannot give your assets to X person with your will. So will document gives you that power, that flexibility that you can distribute your assets to anyone you want.
Listen, ladies, just take control, take ownership of what you own, decide who you want to give what to, and just put your stamp on it and say, I will decide, not the law, not my family, not people later who are
Yes.
trying to sit and figure out. And I'm sure you've all experienced this, right? When somebody passes away, and I've seen this happen so many times in close family relatives, there is so many things that are left behind, and then there is a fight over who gets what, and that has led to so many unnecessary upset spaces. Now if somebody decides that this is who it's going to, then there is no fight, because the person decided this is what I had, this is what I gave. So if you want to also not be the reason for heartache when you pass on into another world, make sure you go ahead and invest your time in doing something like this. And if not, talk to Nityananda, because apparently that man has a way of ensuring that he takes all your money and he gives it to you in your afterlife. So,
Thanks.
Nice. Yeah. And even if like just like Shreya earlier mentioned about the sari, so yeah, it's really beautiful document. You can have some personal statements about your personal things. You can share anything. It's not just about the properties. We have seen that clients they have mentioning about the books they have. It's paintings. It's about any aesthetic items they have. So you can mention about anything, your collection of watches or anything. It's not limited to your flats or any fixed assets, but you can mention everything you own and you love.
so the first question is going to be my team. Decide and tell me what you all want from what you know I own. When I'm making my will, I shall remember all of you.
Of course, your jewelry. I'm taking dibs. Okay, folks, thank you so much. Also, Monica, if someone wants to continue this discussion and know more, how can they reach out to you?
Sure. So first of all, I'm gonna share this PPT with you. You can share these slides to all of them. And then if anyone wants to reach out, I would like to offer the video consultation to all of the attendees. And then I'll share the details and the links via email to Arushi. She'll forward it to all of you. So we can start with the video call. And if someone wants to meet in person, our lawyer can come at your home and discuss about your specific situations and guide you. And then we can take this forward and then draft it and register it. So it's pretty simple. We just need to take that first baby step.
Correct. And so everyone who has RSVP'd for the session, I will be sending you a post-session email this week with all of these details, so you can go ahead and ask a few more questions. Before we end the session, do we want to quickly turn on our cameras so I can, capture this moment and thank Monica so much for this session. This was much needed. Really big thank you to you and big thank you to AasaanWill as well.
Thank you.
Come on,
Thank
turn
you,
on, turn
everyone.
on, turn on cams.
There
There's
we
no such
go.
thing as not being camera ready. So don't worry. Just yay, some familiar faces. Good to see you, folks.
Yay.
Come on, more people.
All right.
We can't have 6 blocks of video and then all photos and icons. Also, those of you that don't have a photo, my team tells me it's important to put a photo in Teams. So put a photo in Teams.
All
3,
right, folks, I'm going to count down to
person
3,
random.
2, 3, 2, 1. Cheese. And that's it. Thank you so much, Monika. This has been a fantastic session. Thank you to everyone for joining. Thank you to Shreya.